Welcome to our program today, everyone, entitled PTAB Proposed Rule Changes, What's In and What's Out. Before I turn the presentation over to our speakers, I'd like to go over a few housekeeping items. Today's program will last approximately 1 hour, followed by a short question and answer session. We encourage you to submit written questions during the program. Please type your question into the Q&A widget open on the left-hand side of your screen. We will respond to questions at the end of the program, time permitting. Otherwise, we will follow up with you via email after the program. The webcast console you're looking at can be completely customized to your liking. You can resize or move any of the windows that you have open, including maximizing the PowerPoint presentation on your screen. If you experience any technical difficulties during the presentation, please visit the webcast help guide by clicking on the help button below the presentation window, which is designated with a question mark icon. The PowerPoint presentation will be available on our website at Foley.com in the next few days, or you can get a copy of the slides in the resource list widget on your screen. As a reminder, today's program is being recorded and will also be available on Foley's website in the next coming days. Foley will apply for CLE credit after the web conference. If you did not supply your CLE information upon registration, please send an email to me, Sivan Galinsky, at sgalinsky@foley.com. To be eligible for CLE, you will need to be logged into the program and also answer a polling question during the program, which will appear later. As a final note, those seeking Kansas, New York, and New Jersey CLE credit are required to complete the attorney affirmation form in addition to the polling question that will appear during the program. A 5-digit code will be announced during the presentation. Please email the form to me again, Sivan Galinsky, at sgalinsky@foley.com immediately following the program. A copy of the form is available in the resource list that is on your screen. That's all I have for now. I would like to hand it over to our presentation speakers today. Steve?
Thank you very much, and welcome everybody. Thanks for joining us today. I'm Steve Mabius. I'm a partner in the Washington office of Foley and Lardner. I serve as the editor of Foley's PTAB Trial Insights blog. And my practice includes work on both the petitioner and patent owner side. My background is in biotech and pharmaceuticals, so most of the cases I've worked on in the IPR area relate to that subject matter. Paul?
And my name is Paul Hunter. I'm a chair of the electronics practice. I'm a partner in the San Diego office of Foley and Lardner. I'm also a member of the Patent Office Trials practice. I have participated in approximately 15 or so IPRs on both the petitioner and patent owner side. And to start off, we wanted to briefly go over an agenda. The presentation will start with a brief background of what led to the rules package, some of the rationales behind the proposals. Then we will provide a review of the major proposed rule changes, their strategic impact on practice for IPRs, CBMs, and PGR. We'll also like to discuss the impact of the balance of power between patent owners and petitioners. Steve and I will try during the discussion to provide insights and practice tips on how the rule changes can best be used and practical suggestions on what patent owners and petitioners may do. Finally, we'll wrap up and try to answer whatever questions we can. With that, I'll turn the time over to Steve to talk about what led to the rules package.
Thanks, Paul. As background, I think it's important to recognize that there are a number of concerns expressed up to this point by both patent owners and petitioners with the AIA proceedings. I've listed a couple of them in this slide, and I think the Patent Office has been very proactive in conducting meetings around the country in an attempt to gather input about these concerns, and this rules package is one example of the Patent Office's efforts to try to improve the system and deal with some of the concerns that people have expressed about how difficult it is to amend in the case of patent owners, concerns about whether broadest reasonable interpretation is the right claim construction, concerns about page limits and other types of gamesmanship that have resulted from some of the limitations. I think there's a careful balancing here because the Patent Office has a heavy workload in trying to make sure that these proceedings are conducted efficiently and within the time limits prescribed by AIA. So after gathering this input from the public, the Patent Office has produced this 113-page rules package which lays out responses to the comments as well as the initially proposed rule changes to try to deal with some of these issues. And I wanted to point out that the Patent Office is going to be conducting additional road shows to gather input from the public before there's final implementation. And one other announcement is that as part of this continuing effort to reform AIA proceedings, the Patent Office has announced a pilot program where a single administrative patent judge is being proposed to make the initial institution determination rather than having a panel of three people, of three APJs deciding that. And this is part of their effort to reduce the workload and increase efficiency as they deal with a large number of proceedings that they're faced with. And that announcement just came out a couple of days ago, and we've provided the citation to the Federal Register where you can read more about it.
And Steve, you know, that pilot program, I think is very interesting because, as you know, we are tracking each of the administrative patent judges and kind of their tendencies of which side they tend to decide on. And we've noticed that some of the APJs are very heavy favorites for petitioners, and others are very heavily favoring the patent owners. What do you think? What kind of impact will this have? Obviously, it'll streamline and allow the PTAB to process more of these. But do you think we might see the numbers change as far as the statistics that we find and how the panels are ruling for institutions or not?
I think there is a possibility that you could see increased variability resulting from limiting the people who are deciding it just to a single APJ. But to some extent, the statistics that you talked about, Paul, are probably a reflection of the different areas of technology, and there may be particular areas that are more susceptible to challenge than others. So I'm not sure that it entirely reflects the tendencies of particular judges, and I think for that reason you have to be cautious when looking at the statistics. But there is certainly the possibility that this could lead to increased variability. But overall, I think the APJs work hard to make fair determinations, and certainly there are plenty of decisions where they've instituted IPR as a panel, but then in the final decision as a panel unanimously, they've ruled in favor of the patent owner. And in addition, there are other cases where individual administrative patent judges have dissented from the panel. So I think we'll just have to wait and see how this works out, and I think that's one of the reasons the Patent Office is doing it as a pilot and why they've proposed it as a pilot, to see if it's really helpful and how it works out.
Well, as the rules say, anyone may comment on the proposal, both as to what is proposed and what is not proposed. We've seen that it appears to be the office's practice to take all of the comments that are provided and attempt to respond to all those. The deadline for the submission of the comments is October 19th. The slide here shows the email address where the comments can be sent. We have in the past for clients sent comments in on behalf of clients, both disclosing and not disclosing who the clients are that are submitting the comments. The question is, how much will the PTO modify the proposed rules before implementation? As Steve and I go through the proposed rules, some of them seem more ripe for modification than others. Some of them look like they may be just codifications of what the practice already is, and it's likely that the office is not going to modify those because it's really just putting into print what the PTAB has been doing.
Yeah, I think that's a great point, Paul, that we don't know how much more they may be modified, and in part that will depend on the comments that are received up until October 19th from the public. But as a general matter, there has been a pretty careful analysis by the Patent Office of the initial comments, and I think what they've proposed reflects a careful balancing. So there may be some areas where there's not a lot of further modification, but we'll go through that piece by piece during the rest of the presentation. This next slide is really just an overview of the main topics that we wanted to cover today. And of course, this is a very large rules package. We're not covering every single proposal within the hour time period, but these are the major ones. The first big one relates to the pre-institution part of the process, and that is the patent owner's optional preliminary response. The proposal would allow new testimonial evidence to be included in the patent owner preliminary response. So it frees up the patent owner to use additional arguments and evidence and declarations even to attack the petition before an institution decision. And in order to balance that out, the second proposed change in this rules package would allow the petitioner to seek leave to reply to a patent owner preliminary response. Now, there have been some isolated instances under the current procedure where petitioners have been allowed to do that, but by and large, petitioners don't have a clear right to reply to a patent owner preliminary response, and the proposal here is to give them a stronger basis on which to have an opportunity to reply. An additional clarification is to provide that material factual disputes at the institution stage would be resolved in petitioner's favor. So the tie would go to the petitioner, and we'll explain why that is when we come to that part of the presentation. Another area relates to imposing a Rule 11 type certification on all papers filed with the PTAB, and the potential for motions for sanctions if those certifications are violated. Claim construction is discussed extensively, but largely unchanged in this rules package, and we'll come to that as well. On a more procedural side, the Patent Office is proposing to replace page limits for a number of different filings with word counts, and we'll talk about the potential impact of that. And the last big change we want to cover relates to an increase in the amount of time for parties to exchange demonstratives before the hearing. Instead of the current 5 days, they'll have seven business days before the hearing. Paul?
Yeah, and so the first proposed rule change we want to discuss, I think, is the largest potential change, and that is allowing the patent owner to submit newly created testimonial evidence in its preliminary response. Now, currently, the rules are set up so that the patent owner is only allowed to submit evidence from the original prosecution or evidence that was created in parallel proceedings. The patent owner is not allowed to submit new testimonial evidence in response to the petitioner. And this is a major departure from current practice because it really opens the door to the patent owner providing a lot of evidence that the petitioner may not have anticipated or be able to anticipate, and it really shifts the balance of power from the petitioner to the patent owner, in that the patent owner is able to provide new evidence that may lead the panel to rule in its favor. Now, at the same time, we'll talk a little bit more about the petitioner being able to respond to preliminary response. It seems to me that this change in the rule may add quite a bit of additional cost. The patent owner preliminary response is due 3 months after the filing date of the petition, and up to now, in the cases that I've been in, where we've represented the patent owner, we have a pretty limited universe of evidence that we're able to work from. Opening this up to new testimony in the form of expert testimony and other documentation, provides the opportunity to really expand the time and effort and cost that the patent owner may expend in preparing the preliminary response. Steve, on the preliminary responses that you've worked on, do you think this, what kind of impact do you see this having?
I could see this one having a pretty significant impact. To take some examples, if you have a petition that's filed with an expert declaration where some sort of experiment has been performed and evidence of an inherent result from carrying out the experiment based on the prior art is presented in that petition, if that happens to be a piece of prior art that the patent owner has never dealt with before, it's really difficult to respond to that in the preliminary response under the current procedure without being able to conduct a rebuttal experiment of your own and potentially counter that expert declaration that's in the petition with your own expert declaration. So I think this could be a pretty dramatic impact in cases like that. And the challenge will be, of course, that you only have 3 months from the time the petition is filed to prepare that preliminary response. And if that's going to include actually running certain tests or experiments, it may limit how much you're able to get done. But clearly this is a big impact for patent owners being able to draw upon new sources of evidence and use rebuttal experts at the pre-institution stage.
Well, Steve, at the same time, I think that, it seems that this change is more fair for the patent owner. The petition is presumably going to have new arguments that weren't presented in original prosecution or new arguments that weren't presented before. And, often new arguments are going to require new rebuttal evidence. And, patent owners, in my opinion, I think have been at a disadvantage because they've been limited in how they can respond.
Absolutely, and I think that's what this is intended to address, is to give the patent owner an opportunity to address it pre-institution. And the end result may be that if patent owners are successful, that the institution rate could actually go down by virtue of this change in the process.
Yeah. Well, I do think that this change will result in increased costs, although I think it'll also result in better evidence and better decisions at the institution stage. Let's turn now to something that goes hand in hand with that change, and that is that the petitioner can seek leave to reply to the patent owner's preliminary response.
And this is one area, Paul, that's a little bit unclear, but the proposal is to allow petitioners to seek leave for replying to the preliminary response. And under the current system, they have no right to reply, and this proposed rule isn't giving them an automatic right to reply either. It just says that they would be able to seek leave to reply. Presumably, if the patent owner has taken advantage of the other rule change we just discussed and included new evidence or a new declaration, that would be the kind of circumstances under which the PTAB would give leave to the petitioner to file a reply before the institution decision. I think we'll have to see in practice how this works out and what scope of reply is authorized. For example, if the patent owner has provided new experimental evidence in the patent owner preliminary response, does that mean the petitioner should be allowed to present rebuttal experiments? And how will this all work out, given that there's only a 3-month time period between the patent owner's preliminary response and the board's decision to institute? I think the timing issue is very important, and petitioners will have to act very quickly after reviewing the patent owner preliminary response in order to seek leave early enough so that they can prepare a reply and get it turned in within whatever time limit the board is going to set. And obviously the board's going to need time to review all these additional papers and still be able to render their institution decision within 3 months of the patent owner preliminary response. Yes,
Steve, timing is certainly a big issue. I've noticed in the IPR proceedings that I've been involved in, when we have to go to the PTAB, to the board to ask for permission to file a motion or something, that timing is very important to the decision. You know, the earlier we make the request, the more likely the board is to grant that. Now, you know, one criticism about this is, you know, it really seems that the proposed rules are expanding a great deal on what goes on before the institution of the trial decision is made. You know, the initial purposes behind the post-grant practice was to really streamline and to move away from the costly procedures in litigation. And, by expanding the patent owner preliminary response and by allowing the petitioner to reply to those responses, it really is adding quite a bit more to the process, and it's getting squeezed into this pretty short time period. And one other comment, and I don't know what you think about this, Steve, but by the petitioner having the ability to seek leave for a reply, they're getting the opportunity to present their arguments, even though they may not submit them because that leave may be denied. But the petitioner is going to, the board's going to ask the petitioner, well, what do you want to say? What are the arguments that you're going to make? And so even if the reply is not formally introduced on paper, it's going to be made to the board.
Those are very good points, and I think that's why the USPTO is proposing it in the form of seeking leave rather than giving petitioners the automatic right to reply whenever new evidence or declarations are presented in the patent owner response, because they recognize that they need to consider the situations carefully where they do allow it, because it will be difficult to implement, and it does expand clearly the scope of the proceedings prior to institution, and there's also the risk that you pointed out that petitioners may present their arguments, at least in a telephone conference with the board, as part of their request to seek leave, although ultimately, if no evidence is presented, I think the board would make its decision without relying on it. But you're right, they could use it as an opportunity to present arguments.
Now, the next proposal is really a codification of the existing practice. The proposed Rule 42-108 states, as the slide shows, supporting evidence concerning disputed material facts will be viewed in the light most favorable to the petitioner for purposes of deciding whether to institute an inter-parties review. And this is something that we've seen in a number of IPR proceedings where the petitioner and the patent owner dispute material facts, and the board makes a decision based on the record in front of it, viewing the facts most favorable to the petitioner, and then after the trial is instituted, the two sides submit evidence and arguments for their sides of the dispute. The comments to the proposed rule indicate that allowing some type of cross-examination in order to resolve the disputes isn't really feasible. The time is very short, and the proposal is just to err on the side of the petitioner, so that if there's not a clear way to rule either for the petitioner or the patent owner, that the petitioner is going to get the benefit of the doubt. Steve, have you seen this kind of tie goes to the petitioner in the IPRs that you've done?
I have seen some examples where in the institution decision, the board would use reasoning like, based on the evidentiary record before us at this time, only for purposes of this institution decision, we conclude that this prior art reference is sufficiently publicly accessible to be useful as prior art or to be applicable as prior art. And so they kind of make a threshold determination where they may be viewing it in a way that's more favorable to the petitioner. It's sort of a tie goes to the petitioner for purposes of that institution decision, but at the same time, they're still taking the position that the burden to establish unpatentability is always on the petitioner. I think this is a reflection of their careful balancing given what they're proposing to do with the patent owner preliminary
and certainly the fact that it is the evidence concerning disputed material facts versus conclusions of obviousness or anticipation. The next area that of the proposed rules is a Rule 11 type certification, and this portion of the proposed rules really opens more questions than it provides answers. The language of the proposed rule says, to the best of the person's knowledge, information, and belief, formed after an inquiry reasonable in the circumstances, and then you can see on the slide that the rule is the certification, much like the litigation Rule 11, that the information submitted isn't for an improper purpose, and it's not a frivolous argument, and there's support, and the denials are based on evidence. Now, some of the questions that this brings up that we've seen in a few IPRs, is it a violation of this type of certification to file a challenge where the petitioner is not being accused of infringement, or the petitioner is challenging a patent that may not even be in something that it practices, that the IPR itself is being used for tactical reasons or to try to gain some type of advantage over the patent owner. The certification doesn't say anything about that. It doesn't also say anything about some of these parties that we've seen filing challenges and being called IPR trolls. IPR petitions that are attempting to create some type of adverse impact on the patent owner, whether it's affecting the stock price of the company because the patent on a valuable pharmaceutical, for example, is being challenged, and if institution is granted on the IPR for this patent, it would dramatically affect the valuation of the company or the price of the stock. The Rule 11 type certification also talks about the law firm being jointly responsible for a violation being committed. So, the law firm can't just get off by pointing to its client saying, well, my client told me to do this. The law firm also has a responsibility. The motion for sanctions must be authorized by the board. Some of the other requirements are listed there on the slide, and as I said, the proposal opens up a lot of questions that aren't really addressed, and hopefully through the question submission process we can get some clarification on, will there be some type of due process where the party that's being accused of a violation of the certification will be able to respond to the allegations. It's not clear that, it says that the board may award to the prevailing party the reasonable expenses incurred for the motion. The questions that this brings up, what part of the effort that the law firm was expending, or maybe the in-house firm was being used for the motion.
Paul, a couple of quick comments on this.
Yeah.
As you mentioned, we had seen some situations where the PTAB allowed a motion for sanctions under the existing rules. And I think in those instances where they allowed the motion, it was because the party pushing for it had access to certain evidence that suggested an improper purpose. And given the very limited discovery available in these proceedings, I think it will be relatively rare for a party to have evidence available to it that would allow it to pursue a motion for sanctions. And it seems like the Rule 11 type certification requirement is a way to just sort of remind the parties the importance of verifying their filings. And I think the USPTO may not grant frequently leave for a party to file a motion for sanctions, but it'll be interesting to see what happens with respect to the motion for sanctions that was recently filed in one of the Celgene IPRs, and we may get some hints about how the PTAB will handle situations where a petitioner is not an actual company competing against the patent owner and may be filing the petition for different reasons than we typically see. So we can look forward to getting some at least initial views of what the Patent Office is thinking about motions for sanctions from that proceeding.
Yeah, and Steve, I had a situation in an IPR that I was working on where we believe there was a basis for some type of sanctions, and the board was very hesitant to take any action. They did not feel that it was really in their area to make a decision on that, and we were suggested that we could contact the ethics board of the bar where the attorneys were licensed to practice, and this does provide a mechanism for parties to be able to make a challenge when there is some type of circumstance. But I agree that we're likely to not see that the board will grant a lot of these types of motions.
Our next topic relates to claim construction during AIA proceedings, and despite having received quite a lot of comments about whether it was inappropriate to have broadest reasonable interpretation, or BRI, because of how difficult it is to make amendments, ultimately the proposed rules would not make a change in the BRI standard, except for a narrow group of patents that are going to expire before the time of a final decision in the proceeding. In those cases, in that narrow group, Phillips-type claim construction will be applied. And one of the responses from the USPTO to the comments who were pushing for elimination of BRI is that the Patent Office wanted to remind people that amending claims is not as hard as it was, because they've clarified that in the master image decision that only prior art known to the patent owner must be addressed. And so when you present amendments now under the clarified standard, the USPTO is suggesting that it may not be as difficult as people perceived it to be initially when some people thought you had to show that your amended claims were patentable over all the prior art in the universe. So the Patent Office is referring to its own recent clarifying decisions to say that amending is easier, and therefore BRI should be retained since the patent owner has the ability to fix the claims through an amendment. Now, I think the reality is that most practitioners would agree it's still pretty hard to amend the claims. So it's possible that there will be further comments from the patent owner side on whether BRI remains the appropriate standard for AIA proceedings. The Federal Circuit has basically affirmed the Patent Office in its use of BRI, although there's a pretty strong dissenting opinion from Judge Newman. But for now, it looks like BRI is going to remain with us in AIA proceedings.
So the next section of proposed changes relates to the change of going from page limits to a word count. And this would affect the petition, the patent owner's preliminary response, and the petitioner's reply. Now, parties had complained quite a bit about how hard it was to comply with the page limit, and the parties had resorted to all sorts of ways of citing to declarations and moving different things around. But in the end, I think this is an example of how sometimes you may not want to complain because you don't like the resolution. I went through and did a review of about a dozen or so IPR petitions that our firm had filed, as well as other firms had filed, and most of the petitions were, if not right at 60 pages, they were near to 60 pages, and more than half of those were well above the 14,000 words limit that it would be is the proposed word count that would be applied to the petition. And so, one of the changes, one of the reasons for that is words and claim charts would count towards the overall total. Now, 14,000 words is probably a good estimate of what goes into a 60-page petition. A lot of the petitions we looked at were right around 14,000 words, but particularly where the petition had quite a few claim charts, and there was an effort to try to make sure that everything was fitting on the 60 pages. The words were much more than 14,000. The proposed rules also say that instead of 25 pages for reply, the limit would be 5,600 words. So it remains to be seen if go ahead, Steve.
Yeah, I was just going to jump in, Paul, with the fact that 14,000 words seems like a lot of words to me, and in 60 pages, for that matter, is a lot of room to flesh out an argument of unpatentability in an initial petition for IPR. Yet we've seen a number of examples up to this point where petitioners had attempted to go beyond these limits by putting arguments into accompanying declarations and then using long cites to the declarations rather than paralleling the arguments in the petition. And I think the Patent Office, given the workload that they have and the time limits that they have for handling these proceedings, has tried to put a stop to that, and in some cases they've denied the petitions on that basis. And so I think that although it's expensive for a petitioner to divide up grounds of rejection and put them into separate petitions, I think people are well advised to follow the limits that are set, whether it's a word limit or a page limit, and not try to overload or overstuff their petitions with arguments, because the board has shown that they're willing to dismiss petitions in which that happens.
All right. It'll be interesting to see, Steve, how the comments come back to this proposal, whether folks are actually going to be happier with page limits rather than the word limits. The complaints may be redirected, and folks may say, well, actually, we're happier with page limits than word limits. Now, I think at this point, Sivan, do you have a message on CLE credit?
Yes, thanks, Paul. At this time, we're going to read the CLE code for the program. If you're in need of CLE credit today, please enter the 5-digit code I'm about to read into the polling question on your screen after it's announced and press the Submit button. Again, just as a header, make sure that you press the Submit button on the slide and do not enter the code in the Q&A portion, but actually in this slide page. I'm going to be able to read the code only twice, so please pay attention. The code is the number 5, the letter V as in Victor, the letter I as in icicle, the letter A as in apple, and the letter T as in Tom. Again, I'll read the code once more. The number 5, the letter V as in Victor, I as in icicle, A as in apple, T as in Tom. And just a reminder, please enter the code into the current slide that's on your screen and press Submit. We'll leave this up for about a minute to give you a chance to enter the code and press Submit, and then I'll hand it over to Steve and Paul in about a minute. All right, Steve and Paul, please move forward. The poll is now closed.
Thanks, Yvonne. I'd like to cover our last major topic in the rules package, which is the increase in the time period for exchanging demonstratives before the final hearing. And this isn't really a major change. It's just an increase in the time period. Most parties have used PowerPoint slides or excerpts from exhibits as demonstratives during the final hearing, and the parties are required to exchange them in advance so that any objections can be made if the record has been mischaracterized or if there are inaccuracies in the proposed demonstratives. And I think, from a strategic point of view, people wrestle with the issue of whether you want to have detailed demonstratives that give the opponent more time to prepare for the final hearing to respond to that, and this time limit will further increase the amount of time that each side has to analyze proposed demonstratives. And so I think people have struck a balance between how much detail goes into their demonstratives, and now they just have a little bit more time to study what the opponents are submitting and to resolve any disputes. One type of dispute that sometimes arises with these demonstratives is when one party wants to present video testimony from the depositions of the declarants, and at least in my experience, the board has been pretty reluctant to allow video testimony. I don't know, Paul, if you've had experience in that area or with other kinds of demonstratives that created controversy prior to the final hearing.
Yeah, I haven't had a video controversy, but I have had a situation where the opposing counsel was submitting PowerPoint slides that had new arguments that had not been included in any of the previous papers. And we had a conversation with the board, and the board required that the party remove any of the references in the demonstratives to arguments that had not been previously presented. I have seen a number of strategies with regards to demonstratives. It seems pretty popular for folks to put together a very large PowerPoint. I've seen 120 pages of slides, 90 pages, just so many slides that it's impossible that they'll be able to go through all of the slides in the short time they have. The most recent oral hearing that I had was both sides had 30 minutes each, and opposing counsel had 117 slides. The strategy there was that I believe the opposing counsel wanted to lay out his entire case in a PowerPoint format, and he was hoping, I think, that even though he wasn't going to have the opportunity to go through the entire presentation during the oral hearing, that the panel would see the summary format, the diagrams, and that it would have some persuasive effect.
This next slide is just a recap of the changes we just discussed, and you can see the rule numbers cited in the far left column and a summary of what the proposed changes and who benefits. And I think in the end, the proposed rules are a pretty careful balancing that depending on how they are implemented in practice and the extent to which the board provides leave for the petitioner to reply to the potentially expanded patent owner preliminary response, it may be a wash in the end. I don't know that it's clearly going to favor one party or the other, but I think the Patent Office is hoping that perhaps the rules will make the process fairer and lead to better, higher quality institution decisions. Because I think that, as Paul discussed, that's the biggest change in this whole package.
No, I agree, Steve. I think that the proposed changes do seem to cut both ways. Some certainly favor the patent owner, and others the petitioner. The greatest change, I think, as we look at the proposals, are the expansion of the pre-institution practice, the opportunity that the patent owner will have to present new evidence that heretofore the patent owner was unable to do. That really expands the what may happen during the time period before the decision. I think that time period is pretty short as it is, and I think the timing is going to be even more difficult as the patent owner attempts to craft its petitioner in response has to go through and study the new evidence and make requests to have leave to respond to that new evidence. The certifications are also very interesting. It remains to be seen whether the Rule 11 type certifications are going to reach out and extend to parties that are not really in a dispute with the patent owner, and whether the certifications will be used on a limited basis or not. So I think that's a good wrap-up. Steve, should we go to some of the questions that we've received?
That sounds good.
So, Steve, one of the questions is, does this mean that a party must file a motion to leave to file a motion for sanctions after the safe harbor period expires? You want to address that? I'm going to look for the slide on the Rule 11 certification.
Yeah, I'm not sure I follow the part about safe harbor period, but I think that the Rule 11 type certification is going to apply to all papers filed by each party. So it's going to apply to the very first paper, the petition, any papers filed by the patent owner, and any responsive papers filed by the petitioner thereafter. And I think that if a party has evidence or reason to believe that the Rule 11 type certification has been violated in that filing, then they would need to contact the board for a conference call similar to existing practice relating to a motion for sanctions and present their reasoning why they should be allowed to file a motion for sanctions. So I think the rule itself is not clear as to the timing of these requests, and it may depend on where in the proceeding they occur. Paul, do you have any comments on that as well?
Well, I think the reference to safe harbor may refer to this 21-day period that provides the accused,
the curing period, right?
The curing period that the accused can fix whatever the issue is. But a lot of questions remain about. Well, sure, they have 21 days to cure, but some of the problems may be hard to cure, and most of the motions that are filed with in a PTAB, you have to get permission from the board to file the motion, and so I would assume that this type of certification is the same as the other motions, that the challenger would have to go to the board and say, we want to file a motion for sanction, and this is the basis for doing so. Were you going to say something, Steve?
Yeah, I was just going to add, I think that the first step in the process really is requesting a conference call with the board. If one party believes there's a basis for filing a motion for sanction, the process would start with that phone call, and I'm sure that the board would then reiterate that there is a time period during which the other party would have to correct it, because this safe harbor period or correction period of 21 days is built into the process. So I'm assuming that it would happen after that initial call with the board.
I just want to point out that those that are listening online, there's a cutoff at 1 hour, and so depending on when the clock strikes the top of the hour, we may be cut off. if you dialed in, the audio will continue. I don't know if we have any more questions from the audience. Steve, do you have any concluding remarks?
Nope. I'd just like to say thank you very much for joining us today. And thank you, Paul.
Absolutely. And I just want to put a plug in for the blog that we have, the PTABtrialinsights.com. We have a number of subscribers to the blog. It gets populated with some very well thought and timely information. As a firm, we are looking every single day at the IPR decisions that come out, and we try to populate the blog with very timely and very helpful information. And of course, if you have questions that you'd like to email either Steve or I about after the presentation, we will do our best to get back to you as soon as possible. Thank you, everyone.